Good evening, everybody, and thank you very much for joining 42BR Barristers' latest family law webinar, R&C, Where Are We Now? This is the third instalment in our 2025 January to July family series. My name is Charmaine Clubb, and my colleague is Sharan Bhachu, and we are both practitioners in the family law team here at 42BR. If anybody has any questions, feel free to put them in the Q&A box. And if we have time, we'll deal with them at the end, or we can follow up by email. And finally, we will also make sure that a copy of the recording, the slides and a feedback form are circulated over the next few days. Sharan, you happy to kick us off?
I am, yes. So welcome to our seminar. We wanted to look at what's been happening since I think we all experienced the flurry of cases towards the end of last year, when we had to adjourn off all of our final hearings because we didn't have any information about post-adoption contact or when there were queries about whether that was the right thing to do. And of course, that came as a result of two things: the case of R&C, which I'll talk about in a moment, but also the guidance that came out towards the end of the year of the Public Law Working Group. And when I was looking at these, when I gave a talk to a local authority last year with another colleague of mine, was the dates of R&C and the date of the Public Law Working Group guidance, which I think was the 30th of October for the R&C judgment, and I think it was the 7th of November yes, for the Public Law Working Group. So they obviously came out very close to each other, and it caused quite a lot of consternation across, I think, the family law bar, but in the right way. So what I wanted to do, first of all, was just, before we come on to where we are now, because it's important to see where we are, but we need to also know the background to what we're dealing with. And so I wanted to look at R&C in a little bit more detail. For those of you that haven't had a chance to read the judgment, please go back and read it in your own time. It's a really, really helpful judgment. And what it does do is deal with a lot more information about the canvas that we're dealing with that we won't be able to go through in detail in this seminar. So this was a case where the local authority appealed against the refusal of a placement order. The placement order was refused by the trial judge because he felt, having considered all of the factors and the welfare issues, that adoption was in fact inconsistent with the children's needs for continuing contact with members of their birth family. And in this particular case, it was direct contact that was being considered with their siblings. This was a sibling group of children aged 6, 5, 3 and 2, and it was in relation to the youngest two that the placement orders were being sought. Now, interestingly, the local authority's position had been consistent all the way through, that they were committed to the promotion of direct sibling contact, and they were clear in their care plan that they would search for adopters who would promote this. Mr. Justice Baker gives the lead judgment, and again, I really urge you to go back and read it if you can, because what it does do is give us an overview of the changing nature of adoption since its introduction in 1926 and of the developing case law. It deals with the use of Section 26 contact orders, which of course is a very rarely used mechanism. But it also makes really good reference to the President's two lectures on adapting adoption to the modern world. I'm not going to go through those lectures in details or parts of the judgment that refer to those two lectures in details, but it's really important that those are read in conjunction with this judgment. Now, the Court of Appeal, when considering this case, allowed the appeal, and they were clear that they had very carefully considered the advantages and disadvantages of long-term foster care for the two young children, as opposed to adoption, and they felt that the placement orders and the adoption was the right way forward. But what they did do was consider that direct contact with the siblings was a fundamental need for these children. And so they did make a Section 26 order for direct contact 6 times a year and also provided recitals to the order. And I do want to just read out those recitals because it's important to really understand what the court was trying to do in setting the template. And that's a term that you'll hear us refer to a few times during the course of this seminar, but also judges and advocates when they are constructing their arguments in terms of whether it's adoption, whether it's long-term fostering, and if it is adoption, what post-adoption contact needs to look like. So in R&C, the recitals that were given were as follows. The local authority confirming that under its care plans and during its search for prospective adopters for R&C, that the local authority would A, arrange direct inter-sibling contact between the subject children and their siblings, N and Y, 6 times per year. So really specific and really setting the template for going forward. 2, that the local authority would search exclusively for and would match the children only with prospective adopters committed to facilitating inter-sibling contact set out above, and who would propose to adopt both of the subject children. So again, really specific recital as to what the local authority were going to be searching for. And I think number 3 comes into that in the event that prospective adopters committed to facilitating inter-sibling contact as set out above had not been found within 6 months, the local authority would apply to the court. Now, lots of you will recognise that that's very different to often the situation that we find ourselves in when we've managed to get the local authority and the court to agree to a certain amount of searching for adopters who will promote contact. But we normally end up with a recital or a change to the care plan that after 6 months, if the local authority have not been able to match, then the search widens. This is very specific and very clear that contact is the fundamental position going forward. And despite the Section 26 order, there was also a recital that it was this court, of course, the Court of Appeal, it was their view that after adoption, R&C should continue to have direct contact with N and Y, their siblings, 6 times a year. So really reinforcing the position. And just going back to the President's talks, which I'm not going to go into detail, but one of the things that he refers to is that setting the template for direct contact going forward at the placement order stage, it in fact allows everybody going forward to have a known about these children, what it is that these children will need in addition to other needs going forward for post-adoption contact. I'm going to hand over to Charmaine now, who's going to deal with the Public Law Working Group and their recommendations.
Thank you, Sharon. So, as she's already said, hot on the heels of that case, we then had the report from the adoption subgroup of the Public Law Working Group, recommendations for best practice in respect of adoption, and that came out on the 7th of November last year. The overriding conclusion of that report is that wholesale reform to the adoption process is needed. I'm sure many of you know this already, but just to set out my stall, the Public Law Working Group was established by the President, Sir Andrew McFarlane, and the adoption subgroup, chaired by Mrs. Justice Judd, and with a membership of professionals from across the sector, had been working hard on the review, consultation and report for some 4 years. The report focuses on 5 key areas: international adoption, consensual adoption, access to adoption records, processes and procedures in court, and contact. The report is extremely detailed and provides numerous recommendations across those 5 key areas, and I'd really recommend anyone who hasn't already read it to go away and read it in their own time. The intention of the report is to provide a review of the adoption process and to be a catalyst for positive change in an age of social media in the modern world. And it also serves as a useful tool for those working in adoption and related services. The report finds that the model of adoption has adapted and changed really quite drastically over the years, and that more needs to be done to make it effective now, including making use of digital tools for training, information, and contact. The report highlights that the original model for adoption was of children who were born illegitimately or to impoverished or young parents. And so children were effectively relinquished at birth to be placed with more financially and socially secure childless married couples. And this is an issue that the president also touches upon in his 2 lectures. Of course, since then, the landscape has changed quite significantly. And now most children are adopted from care, although there does remain a small number of cases where babies are relinquished for adoption even today. In terms of the numbers, that's also changed quite a lot, peaking at around 25,000 adoptions in the late 1960s and falling to around 2,950 in 2022. So clearly what we're grappling with today is of rather a different character, both in terms of scale and in terms of what we're dealing with. And Sharan, I think I'll hand over to you now for the recommendations.
Yes, so thanks for that, Charmaine, because it's really helpful to understand the purpose of the report and the canvas that it was dealing with. And in fact, the report is extremely detailed. It provides dozens and dozens of recommendations across 5 areas: international adoption, consensual adoption, access to adoption records, processes and procedures in court, and contact, which is of course what we're talking about mainly today. But what I wanted to do was just pull out some of those recommendations because we could be here for quite a long time if we were to deal with all of them. And before I do that, I want to read out the words of Mrs. Justice Judd in relation to the purpose of the report. So this report highlights the need for significant change so that adopted children have more opportunity to keep in touch with their birth families unless it is not safe, and better access to their records. It also calls for changes to process and clearer guidance for international adoptions. And this, I think, is really important, recognising the lasting effect of adoption orders on birth and adoptive families. So just looking at 4 of the recommendations in brief. There needs to be, firstly, there needs to be a change in the face-to-face contact between adopted children and birth families. That, of course, is the sea change that the president was talking about and that R&C envisaged going forward. It's something that I think practitioners have been talking about for a long time, and it's nice to see that actually things are moving in the right way. But what the report also recommends is that there needs to be greater training and greater support and counselling for birth families as well as adopters, because of course we concentrate, don't we, when we're looking at care plans and when local authorities are saying that they're going to be looking for adopters who are willing to promote direct contact going forward, and they have the right training, because that's what's done in order for them to become adopters. There is no training at the moment for parents, birth parents, in relation to how post-adoption contact needs to look and how they can deal with that, because it's not just about the child, is it? So that's a really helpful recommendation. The second one is that there should be a national protocol for a standard procedure for applications made for access to records. That's, of course, post-adoption. There needs to be, thirdly, a simplification of the extremely complex system of adoptions with an international element, including a rewrite of the statutory framework and an urgent need for written guidance. Charmaine, I don't think I've seen any written guidance in relation to that yet.
No, nor I.
And I think it would be interesting to see when it does come through what it says and how it's going to help. And then fourthly, that there needs to be a national strategy for adoption by consent cases. That needs to be developed, and there needs to be, again, training for all, better access to legal advice for birth parents before birth and afterwards. And in those cases, that local authorities bring cases straight away and that the courts list those cases urgently, so they're before the courts as quickly as possible, and that the parents have access to legal advice before we get to the stage of the birth. So really important, and again, a real sea change to where we were before. So what we're going to do now is have a look at, since that guidance and since R&C, some of the cases that have come out and see where we are.
Absolutely. So it's just going to be a whistle-stop tour of some of the authorities that have come out since then. And first, I'd like to deal with REF, which was a recent case. In this case, the local authority appealed due to the judge's refusal to make a placement order. The facts of this case certainly make for interesting reading. I don't know what you think,
yeah,
Sharon. But for today's purposes, I'm not going to delve into the detail of the factual background. Ultimately, though, the appeal was allowed, and at the rehearing, adoption was considered to be in this child's best interests. Mrs. Justice Henk found that the child's extensive history of placements to date, coupled with the failure of her placement with her mother in the community, meant that the child had an overwhelming need for permanence, which was best achieved by adoption. So putting it simply, the child's need for permanence was outweighed by her need for contact, which no doubt would be much more easily facilitated with a long-term foster care arrangement. In terms of post-adoption contact, here we're dealing with a local authority who was really committed to searching for adopters who would facilitate direct contact. And Mrs. Justice Henk deals with this issue rather succinctly at paragraphs 68 and 69 of her judgment. And what she says is this: I have considered whether I should make a Section 26 contact order to set the template for contact between F and her mother. G asks me to say the frequency should be monthly, and if that is not in F's best interests, then she seeks as much contact as I will order. I understand G's sentiments, but what she seeks is not in F's best interests. It would be disruptive and would, in my judgment, undermine F's ability to settle in her forever home. I've accepted the local authority's care plan and their commitment to match F with an adoptive placement, which will facilitate direct contact for identity purposes. In the circumstances, I've reminded myself of Section 1.6. In this case, I do not consider a Section 26 order is necessary. So here, what we can see is Mrs. Justice Henk being content to rely upon the local authority's commitment to searching for adopters who would facilitate that direct contact. And she didn't feel it necessary in this instance to go further than that in terms of setting the template. Now, in contrast, we move on to BCP Council versus M. So in this case, we had a sibling group of children aged 13, 12, 6 and 2. Ultimately, care orders were granted for the elder 3 and care and placement orders for the youngest child. On the benefits of adoption versus long-term foster care for the youngest child, the judge said this: an adoptive placement is more likely to secure permanence for her than long-term foster care. Post-adoption contact will, to a degree, mitigate the welfare risks to H of becoming an adopted person. And if an adoptive placement achieves the best welfare outcomes for H, I do not consider the fact that E, F and G may remain in foster care of itself means that the court should not sanction the care plan for their little sister. So clearly here it's a reminder that each child needs to be considered individually, and the right care plan for one in a sibling group isn't necessarily the right one for the entire sibling group. In terms of post-adoption contact, a Section 26 contact order was made for direct contact with H's siblings and both parents. And the purpose of this was to give a clear directive to prospective adopters about what the court considers to be in the interests of H. It shapes the search for a suitable placement for H, as well as the template for post-adoption contact. And the judge goes on to say, I think it is in H's interests to have a direct relationship post-adoption with her siblings, as well as both parents. However, I do need to be mindful that H needs to be able to settle into an adoptive placement on the one hand, whilst also being supported to maintain her sense of identity on the other hand. And what increases the importance of post-adoption contact are the advantages of maintaining current relationships. And the relationship which shines through as being particularly strong is H's relationship with one of her siblings, E. So in the end, a contact order was made for contact with E 4 times a year, the other 2 siblings at least twice a year, and the parents at least once each per year. In terms of the mode of contact, judge said that needed to be supervised based on the current assessment of risk. And the judge also goes on to say that there needs to be a degree of flexibility in relation to the level of contact. And specifically, the judge said, if the level of contact in the care plan is beneficial to the child, no doubt all concerned will reflect on whether the balance suggests that those benefits can be further increased by there being more of it, or vice versa. So I think really it's important for everybody to have an eye to the future. When these orders are made, often children are very young and nobody knows exactly how things are going to turn out and whether that contact, if it happens, which in this case there is an order that it should, will be beneficial or not. So there needs to be a degree of flexibility. Moving on now to our next case, a counsel versus the mother. So again, the key issue here was whether long-term foster care or adoption best met the welfare needs of these children. Interestingly, both the mother and the guardian supported the concept of long-term foster care, albeit for slightly different reasons. The mother's case was effectively that she wanted the children returned to her at some point in the future. Whereas what the guardian was saying was the children should remain in long-term foster care and continue to be cared for by their current carers. Now, the judge ruled out long-term foster care based on a rehabilitation to the mother at some unplanned and indefinite point in the future, essentially because the multifaceted risks in that case were long-standing and unaddressed. And the judge found that delay, as we all know, was not in the best interests of the children, and the prospect of rehabilitation at some unknown time in the foreseeable future simply had too many risks and too many uncertainties. In terms of the guardian's position, the guardian, I think, made their recommendation predominantly on the basis that the children would be able to remain with their particular carers throughout their lives, rather than being placed in foster care more generally. And she was satisfied that there was a real attachment between the children and their carers, and that the carers were committed to providing that long-term care. In weighing up the competing options of adoption and fostering, the judge said that the court's primary task is to take a decision as to whether one or the other is right for the child in question, balancing their welfare as well as matters of principle. There are powerful advantages to adoption for children of these ages and manifest disadvantages of long-term foster care. In making the care and placement orders, the judge reminded everybody that the court has no power to direct a local authority to place a child in a particular placement under a care order. So essentially, there is no guarantee that, despite everybody's best intentions, that these children could remain with their current carers for the rest of their minority, and there is a risk that there would be placement breakdown and inevitable moves in the future. In terms of post-adoption contact, the judge declined to make a specific order for contact, essentially following the approach in Re-F. However, there were clear recitals about the proposed contact arrangement, including the fact that the court strongly supported it. And what the judge said was this: I've applied the reasoning in R&C. Long-term foster care is not an appropriate option for these very young children and for such a long period of time. As I've already addressed, there is no prospect of rehabilitation to the mother in the foreseeable future. It provides too many risks and uncertainties. Additionally, in this case, there should be the additional benefit of ongoing contact with the mother and sibling, which was not the case in R&C. I'm satisfied that the only option which will meet these children's needs is for them to have the option of an adoptive placement where they can settle into a family and have the security they require to develop their potential. I have considered whether I should make a Section 26 contact order to set the template for contact. I do not intend to make a specific order. This was not supported by the Guardian. I do, however, intend to ensure there are clear recitals to the placement order, setting out the detail of the proposed contact and that it was strongly supported by the court. So, Sharan, having been through those recent authorities, what do you think?
It's really interesting, isn't it? Because when you go back to R&C and then you look at the rationale in each of these judgments, it's really interesting to see where judges are going. I was really struck by the Section 26 order being made in Re-F. I thought it would have been, but I can see why the judge got to where she did. And I was also really interested in the argument in the BCP case where contact was considered to be a fact that mitigated the disadvantages of adoption.
Absolutely. It seems to me that the golden thread running through all the judgments is that adoption is inherently the superior arrangement for a number of reasons. The fact that it provides a forever family for the child, there's less risk of multiple placements, although of course adoptions sometimes very sadly do break down. A child doesn't have the stigma that can sometimes be attached to them of being a child in care. And of course, you don't have ongoing involvement and intrusive intervention of children's services. So it seems to me that that is usually the preferred option. And if the court can set the template for contact moving forwards, that can really mitigate some of the downsides of adoption.
Yeah.
And it seems to me that there's increasing confidence in the courts of making, at the very least, clear recitals to set the template for contact moving forward. Is that also your experience?
I think that's right. I haven't yet done a case where a Section 26 order has been made, but lots of recitals have been made. And what's really interesting, and certainly for practitioners going forward, is that flurry of cases at the beginning where we all had to adjourn off because we didn't have the information. That's all settled down, and that's fine. But there are still some cases that I'm coming across where really proper thought hasn't been given to the particular children in the case and what's right for them in terms of post-adoption contact. And often the local authority do need to go back to the post-adoption team to find out what the realistic options are, how contact can be supported, especially if it's, for example, not a birth parent, if it's siblings who are also in foster care or SGOs, or if it's other members of the family as well, and how that can be supported and promoted. And I've certainly seen lots of cases where important people, important family members of a child, their post-adoption contact with those important people going forward is being considered much more. So for me, what it really has done is, having done this job for over 2 decades, is really open up that conversation that's been tinkering in the background for a long, long time, where we've been trying to get things moving, but it's open now and it's there for discussion and for progress. So be really interested to see where we are in a year's time.
Yeah, absolutely. And perhaps a slightly more philosophical question. I think I already know the answer to this, but do you think this change in approach is a good thing?
Yes.
Because I've certainly heard some debate about it.
Yeah, I mean, I do think it's right to open the conversation, and ultimately it's got to be looked at for each child. And as you mentioned earlier, even within a sibling group, a care plan for each child is very different sometimes, rather than just looking at them as a big group. So I've certainly seen cases that have come back where children have been placed in care and come back. And, you know, with hindsight, if there had been some post-adoption contact with siblings, there may be some different outcomes for those children. So, yes, I do think it's a good thing.
Yes, I mean, for what it's worth, I think so too. I think it reflects the reality of where we are now, and ultimately children, as they grow up due to technology, are able to do their own research.
Yep.
And I think sometimes it's better to make sure that things are planned out in a careful and safe way in advance, rather than things sort of blowing up later on down the line.
And people working together, adopters being able to work together with children, with the families. In terms, I mean, I appreciate it's limited working together, but it's more than we've had. And so, yes, I look forward to seeing how that works.
Absolutely. Well, thank you very much for attending. And we're just going to quickly check if any questions have come through. So if you bear with us for one moment.
I can see that there's reference to some work being done in relation to post-adoption contact. And there's a link for that. Thank you very much for that. We'll have a look at that and make sure that it's included within the YouTube link for this as well. So I just want to thank everyone for attending. I'm afraid we are going to have to come to a close because I've got another event that I need to get to, but the slides will be available post this seminar. We'll make sure, I don't know if they'll be emailed out, or we will let you know how they will be available. Our wonderful Sophie will tell us in a moment, hopefully.
Yes, and just so everyone is aware, our next webinar will be taking place on the 10th of April, where Andrew Pote and Hannah Justiva will be discussing costs in financial remedy proceedings. So hope to see you there. Thank you very much for attending. Have a good evening, everybody.
Thank you.